Good afternoon, Advocate Msewe.
Good afternoon, CJ. Good afternoon to everybody in the room.
How are you?
I'm very fine. I'm very fine. Thanks. I wish you are the same.
I am, thank you.
Thank you.
I just want to start by apologizing for keeping you waiting this long. Circumstances beyond our control. And I also want to place on record that you and I have known each other for a long, long, long time. We were students together, we were neighbors, we practiced together in the same chambers. So we have a long-standing relationship, which will not affect my objectivity in this interview, of course. You obtained 2 degrees from the University of Transkei, a PURIS and LLB,
That is correct.
and you also have is a certificate in advanced program
Alternative
in
dispute resolution,
ADR,
Chief
yes.
Justice.
Okay, which you did through the AFSA Foundation.
Yes.
Your legal career starts many years ago in 1983
That's correct, Chief Justice.
when you joined the Department of Justice as an administrative clerk.
That's true, Justice.
Then you became a prosecutor, a control prosecutor. Then, how long were you in prosecution? 1985 to 1997.
That's possibly true, sir, Chief Justice.
Yes.
It was
And
quite
then-
a long time.
Yes. And I recall that you came to Johannesburg to do pupillage,
That is
having
correct.
decided to join the bar
That is true, Chief Justice.
and started your practice with the Society of Advocates of Transkei in 1997.
That is correct. That is so, Chief Justice.
And in 2021, you obtained silk, or you were conferred with status of senior counsel.
That is true.
You've acted as a judge since 2014.
Yes, Chief Justice. At the time, the Honorable then Judge President Sangoni was the JP.
And you have periodically acted. Your next stint was in 2018 in the Eastern Cape Division
That
of the
is
High Court.
that is so, Chief Justice.
Then last year, you acted as a judge in the KwaZulu-Natal Division.
Correctly so, Chief Justice. I did.
For how long?
First term, the whole first term, January to end of March.
All right. Then in the second term, you acted in the Eastern Cape Division of the High Court.
That is so, Chief Justice.
All right. Have you had an opportunity to write judgments during your? Did you get to write judgments during your acting stints?
Yes, I did, particularly when I was in KZN. I did.
How many judgments did you write?
Yo, I cannot recall, Chief Justice, how many.
It doesn't have to be a precise figure. Just an estimate will do.
Chief Justice, I was doing the motion court, both opposed and unopposed, for the whole term, the expedited term. In the expedited motion court, it was plenty of, it's plenty. Some of them were extempore. Some are written. Yo, I can't imagine. It's a lot.
At the judgments you have attached to your application, the only written judgments you have delivered.
I don't think they are the only ones. It's just that when I was preparing, thank you. When I was preparing to this application, I only pick up those that I could easily pick them quickly.
So there are more.
There are more.
All right. Any of them reported? No?
I do not know, Judge.
Not yet.
I don't know, Judge, at all.
Okay. You have done a lot of other things. You've been involved in the small claims court. In fact, you chaired it for a spell.
That is correct. That's where my heart was, to serve the people.
Where? In the Eastern Cape?
In Mthatha, yes,
All
Judge.
right. And you have also been a presiding judicial officer in SARU.
South African Rugby
The Rugby
Union.
Union.
That's correct. And SANZA as well.
Are you still involved with SARU?
No,
Not anymore.
not anymore. But I still love rugby.
Yeah. And you were at one time chairperson of the Transkei Society of Advocates.
Not once, I think 4 or 5 times.
And other positions.
Yes, Chief Justice.
All right. You also have a published article.
Yes, I don't know whether to term it published article, Judge.
Well, it falls under the question which asks you to list your publications.
Yes, I'm a Uniting Presbyterian Church elder, whereby at one stage there was unification of the PSA and the Reformed Presbyterians. Out of that exercise, I have, together with Professor Koyan and Professor Kerr, there was a division of the Constitution to cater for that unity, to bring the birthright of a Uniting Presbyterian Church of Southern Africa. I was then tasked to do certain chapters of our Constitution of the Church.
All right. What kind of matters do you deal with in your practice?
I like constitutional matters, Chief Justice. I do crime as well. I do administrative matters. I say I love them because in our practice in the Eastern Cape, you take everything that is put on your table. So the choice is not that of yours.
I bet some would say, speak for yourself, Advocate Msiwa. I know a few advocates from that part of the country who I think are inundated with work across the country. I won't mention names. Your CV mentions that you have been a member of the African National Congress since 1984 to date.
Please, to date, that's correct. I still am the ANC.
So if you were fortunate enough to be appointed as a judge, what would happen to that membership?
I will consult whether to terminate it very much against my will if that is the principle. I do not know it by head now, but that in any event will not affect my adjudication and administration of justice in this country. Because even now, if you look, you have a recourse at my cases, I am seeking a situation where the rule of law is observed. Hence, I litigate for the indigent people against the very government, even before the government of national unit. I have fearlessly done so and impartially done so, seeking the ANC government to ensure that the rights of women, the rights of the indigent people of this country are protected and promoted. It will not affect my dispensation of justice whatsoever.
Be that as it may, though, a judge may not be a member of a political party, just so you know.
I take that, Judge. I take that, CJ.
All right. No, I'll leave the other questions to the other commissioners. I'm going to ask Acting Judge President Ntlangulela to put questions to you if he has any.
Thank you, CJ. Good afternoon, Ms. Msiwa.
Good afternoon, JP.
The position sought to be filled at Mthatha is that which has been left by Griffiths J. Would it be fair for one to say, especially for me to say as a leader there, that the fairest one must get is an appropriate replacement?
I assume
measured or benchmarked against the caliber of that judge.
I don't get clearly the question, JP.
In other words,
Are
we
you
need
set?
to replace an apple by another apple, not an apple with a tomato.
This is a.
Is it fair for me to make that suggestion?
It is fair, but I do not know if how is Judge Griffiths really benchmarked. But I hold a high esteem for him.
He was a heavy lifter.
Yeah.
Yeah. Okay. What I see from your profile is that you are senior counsel. In other words, it's fair to measure, to look at you and derive an expectation from a senior counsel who will come to Mthatha and deliver on that standard.
ADJP, I do not measure myself with Honorable Justice Griffiths, but I know I can give it all, as I did when I was in KZN. When I performed the duties of judicial officer in KZN, I wanted the Honorable JP of KZN to replace me with at least 3 acting judges, so to leave that legacy. I'm not afraid of working.
Okay, no, that's fine. Looking closer to your profile, one gathers that little or no mention is made of reported judgments having been written by you, counsel.
Yes, AJP, as I alluded, there are judgments that I should have considered if I had ample time to ensure that my judgments are there. Namely, you may recall that there is a trial court judgment versus the Eastern Cape Premier versus Traco. I was involved in that case from the beginning up to the end. Also, there is a case of the military council versus Sekeleni. Those judgments, I know they are reported. Further, there is also a judgment of Norfolk versus the Minister of Safety and Security. I forgot some of them. This is why they are not here, JP. And it is due to the pressure that my peers were pressurizing me to file this application.
But now my brother sitting next to me can't know about judgments or discussion in this meeting unless they are part of your profile.
I accept that. It is my shortcoming.
Okay. Now, since 2021, you became senior counsel in 2021, up until or for the duration of time when you acted as judge in any of these courts, be it KwaZulu-Natal or Eastern Cape. There isn't a sign that a written judgment, which was reported, is in place.
JP, I'm not in charge of the reporting. As I'm seated here, I do not know when is a judgment supposed to be reported. I have read some judgments which I thought, out of my own intuition, that they are supposed to have been reported, and they haven't been reported. There are judgments that I have read which, to me, do not merit to have been reported. So I am unable to give a prudent answer to this concern.
I'll repeat my earlier statement and suggest that because they are not here, we should operate on the basis that we cannot raise questions with regard to them. That is, they are not in the profile in your papers for the purposes of this meeting.
Judge, JP, I've already accepted that if that is my fault. I take full responsibility of that.
Yeah. And in the papers, one reads a lot about council's engagements in areas where there's less or no practice of the law. I'll substantiate my point. I'll read what I've seen here. SARU, Advisory Committee for the Eastern Cape somewhere, Subcommittee for GCP, Nelson Mandela Central Hospital Board, Commission of Mismanagement of Funds in COCTA, Financial Misconduct Discipline Report, Treasury Regulations, and Maibuye Transport Bus Service. I say this account tells me that you would not have been exposed in an area which encourages agility, writing, so that we know what philosophy the senior council has, and so that we can then say, I can then say to the JSC, this is what we are going to get from this candidate once the candidate is appointed as judge in Umtata. And not only Umtata, Bisho, Makanda, and Kabeja.
Can I start with small claims court, AJP? In the small claims court, I was the chairman of the board to ensure the dispensation of justice at that level. I needed not to write anything, but I was a go-between between the then Deputy Minister of Justice, I forgot who he is, and ensure the administration was there. Let's take the second one, Sanza or Saru. If anyone has played rugby, he will understand the rule regulation 19, that if a player has been cited, the full proceedings are in accordance with the requisites of court process. You meet South African player having violated regulation 19, and out of that, if you preside, you'll find barristers from Australia, you'll find barristers from England, you'll find senior counsel from here in South Africa. And you would make sure that promptly, once a player is red-carded, that decision is done, and you preside over as if you preside in court of law. You appraise the guilty player or the accused player for fouling the other one. of the legal rights as enshrined in our Constitution of the Republic, you make sure, double sure and certain that that player gets a fair hearing. So let me not agree with the Honorable JP. If Judge Lex Mpati was here, he would attest to this, and other senior counsel who have been involved in the South African rugby, both at South Africa, New Zealand, and Australia. Then I don't know the other one. The other one is audit committees. If you are a member or a chairman of the audit committee, there is a lot of law involved there, because there must be compliance by the organs of the state, be it the government departments of the municipalities, to achieve clean audits, unqualified audits, or qualified audits. Run away from the disclaimers. But in order to achieve so, there is a process of capacitating, be it the government officials, through the audits and ensuring compliance. There's a lot of law interesting in that field of auditors to save the government money, to ensure that the misappropriations, to ensure that the lot of infractions that takes place in the government institutions are curtailed. Yes, we do not preside there, but we ensure compliance with PFMA, etc., and report to the cabinet.
Yes, and all that would be more administrative.
Yes.
Than your hardcore litigation material.
Sometimes you even advise. Let's take, for instance, at the Maibuya, I was not a chairman, Maibuya Bus Transport. I was giving advice, legal advices of how that institution should be run. Let's take the Nelson Mandela Academic Hospital Board. What did I advance? There is legality. There is assistance that the government had to benefit out of that, and it also sharpened me.
Yes. Just a follow-up on this question for the last time, but all these activities have not been such that they translated to litigation in the High Court, Supreme Court of Appeal, or the Constitutional Court, where there would be legal debates with you standing, arguing your case, and with you being involved in reportable cases as an outcome.
If I am the chairman of the Nelson Mandela Academic Hospital Board, I advise the government of the Eastern Cape, as I did, how best to save the government money on this litigation of medical negligence, and put and assist with measurements to ensure that, of course, the attorneys or the practitioners who are pursuing or asserting the interests, the rights of the litigants, they are all as well protected. I do not necessarily have to go and in court in person to do those in that capacity.
Now, if appointed as judge, what's going to happen with your engagements in these organizations, just to use a generic term? What's going to happen to them?
If you look at the last one, the Maibuya, I didn't spend over 3 months when I was the board member, because I received an invitation from Honorable Justice Madondo to act in KZN. And immediately upon that, I have stopped doing anything in the form of attending boards or whatever. And at that time, I have been out of the boardship of Nelson Mandela, And all these that you are mentioning, including the small claims court, though I loved them, if I were to be recommended, the first thing I do, as I am talking, I'm not a member of any of those boards right now.
Mr. Msiwa, I think that I would be doing an injustice, CJ, if I don't raise this final question to you. There is instability in Mthatha, whose origin is in the law formations, that is the legal practitioners' areas of operation. There is great instability there. Do you agree with me in making that conclusion? There is instability there. In fact, where you are situated, there is instability there.
I am not sure, AJP. If I
Sorry,
can.
I'm not entirely sure I understand what you mean, AJP. What do you mean by instability?
Okay, may I rephrase my question?
Yes,
Thank you.
please.
If appointed as judge, what contribution would council make in order to stabilize the practice of the law in Mthatha especially?
My efforts will be guided by what I will term Lord Denning's 10 cardinal points of being a judge. I will ensure that I'm humble enough to the practitioners. I will ensure that I treat them with respect and applause they deserve. I will be prompt in delivering judgments. I will be as objective and impartially as a judge is expected. I will assist on the ethical part of practitioners who sometimes I have seen that either when they were prepared to be court officials, a very principle has escaped them, a very legal principle, namely that their duty in court is of paramount to act ethically correct and ensuring that they are there to assist the court to arrive at a fair and a just decision. This is what I have seen through my lecturing and through the observations in court, that this ethical obligation, if not enforced, there are practitioners who are not impressing me in the form of how I was trained to become an advocate. That your main duty in court is not to mislead it, not to grandstand, but to ensure that you assist the court to the best, with the best of your ability that you can. I will inculcate that sense of responsibility to its highest measure for the benefit of the division, if I am recommended. I would, for that matter, avail myself to lecture on ethics, because as far as I'm concerned, ethics are like customs. And every institution needs to have a principles, customs, and values. So that will be my addition.
Can I have a follow-up on? I don't know whether good afternoon, Advocate Msiwa. I don't know whether you understand the import of the question from the AJP. As you know, there are different organizations within the fraternity. I thought that he was asking you in that context. I don't know. I just wanted to intervene so that he understands the import of that question from the AJP.
Well,
AJP can correct
it is his answer, and AJP in Tlangulela will say if it doesn't address his question. Had you finished, Advocate Msiwa?
Yes,
Okay.
Chief Justice, I think I have.
AJP?
I think I must stop here. I'm not here to cross-examine the applicant. Mine is just to bring up the issues. And his is to give us as much information possible.
Thank you,
I do have
AJP.
information. I'm not looking for information. I do have it.
Sorry?
I do have information. I know what makes me to phrase the questions in the manner that I do. And I think that my questions have been clear. If the answer is in full or half or not there, then that's a matter for evaluation. I don't want to cross-examine.
Indeed.
Thank you. So I choose to stop here.
Thank you, AJP. Premier Mabuyane, are you still with us?
I'm still on the call. Thank you very much. Good afternoon once more to you and all commissioners. And good afternoon to Advocate Msiwa. All the best. Few questions. Probably let me try to the point he himself raised when he was speaking about litigations. I'm more interested around the issue of medical legal, as you would know. What's your take on the judgment in Noyela versus Ketelo matter, which we believe it brought about a breakthrough in a situation where government would always been compelled to pay cost of 30 years, whilst most cases of these challenges of cerebral palsy would probably be about 10, 15, 20 years or so. That would be the first question that I have. I'm not sure. Let me wait for you. What's your take on that Noyela case? This is a point that seeks to a problem. I'm trying to further the point that the acting judge president was making around Mtata. There is a perception out there, probably believe, that there is an operating syndicate that collaborates around this issue of the medical legal space and how government is being actually challenged around that space, without undermining the fact that indeed there are serious medical challenges and health related challenges that arose out of negligence, what do you call it? Negligence, yeah, negligences that are happening in the workplace, etc. But I'm more interested on your attitude in case you become a judge. What is your take on that particular? Do you think it brings about a bit of a way on how these matters of the CPs can be handled moving forward?
My understanding, Honorable Premier, is that that case sets up and provides that for future medicals, these hospitals will be enjoined to carry out certain services on those babies of cerebral palsy, namely, for an example, to do physiotherapies, to do a lot of those at certain times with a view of sort of reducing the future medical expenses that the department or the government is ordered to pay by court. That is my first take. The second aspect is, when I was the chairman of Nelson Mandela, I pointed out, and I still point out today, that the problem is systematic. When you talk about medical negligence at Nelson Mandela, the problem that confronted the government was, I'm not sure today because I'm no more there, was that the department, the healthcare services was running short of human resources. E.g., if a nurse or a doctor has died, those people were not replaced. If somebody has retired, those people had not been replaced. It then called upon for immediate replacement of those who live. And remember, the organogram of Nelson Mandela Academic Hospital was not an organogram that really portrays an entity that was supposed to be a national competence. As long as that is left at a provincial level, we advised as the board that there could be a discussion between the provincial government as well as the national government to rate and rank the Nelson Mandela Academic Hospital into the national competency so that it has good organogram to cater for these omissions or for these commissions that occur at the hospital, which results in a huge rocket sky litigation. So that is a means of curtailing the huge escalation of medical negligence. If the hospital is running on a shoelace basis, then there's bound to be these problems. For an example, if at maternity in Nelson Mandela, as we observed, you have on a weekend 5 ladies on labor, and sorry, not 5, let's say 35. And then you have only 2 midwives in that case, in that unit, in that ward, with a single doctor who is not even nearby to be called upon. That's a systematic problem, challenge of how to deal with medical negligence. I would advise that if the government seeks to really curtail and decrease these claims, the government must go home and sit down and say, in terms of the organogram, how many midwives are expected? How many nurses? How many pediatrics, all those type of experts, and be centered at Nelson Mandela. Then there will be reduction. Remembering that Nelson Mandela is fed by 27 general hospitals. It's a referral hospital. So it must be well equipped in terms of human resources, in terms of finance put forward, in terms of even repairing the building itself. That's my take. I am not able to understand and opine on the syndicates of clubs of attorneys who are whatever they are doing what you are complaining about, Honorable Premier. I do not know that. I will always think that if there's such infraction, it's an unprofessional infraction, and that the organs of the state are there to deal with those attorneys or advocates. Thank you.
Are you raising your hand to ask a follow-up question, Commissioner Malema? Oh, okay. I've noted you. All right. There is a follow-up. Go ahead, JP Mlambo.
Thank you very much, CJ. Advocate Msiwa, just for my own clarification and for the benefit of this body, do you practice in medical negligence work in the Eastern Cape?
Not really, JP.
Okay, because I asked this question because I'm aware, based on media reports, that there's an SIU proclamation to investigate lawyers, advocates, doctors, and hospital officials who regarding this whole matter in the Eastern Cape. I'm sure you've read about it as well.
No, I have read the JP a lot about that. And when we heard about it, we're all as concerned as everybody because we do not promote unscrupulous behavior on the part of any practitioner, be it an advocate or an attorney. The SIU, if it is there, is taking long.
Thank you very much, Advocate Msiwa. Thank you, CJ.
All right.
No, just a quick follow-up, CJ.
CJ?
CJ, just a quick
Go
follow-up.
ahead, Commissioner Malema.
The Premier asked the acting judge if he was aware of these lawyers who were engaged in these shenanigans. In his response, he says, which I will deal with in my own chance of asking questions. He said, well, I don't know of anything of that sort, and if there's anything like that, the law must take place, blah, blah. He finishes. Then the JP asked him something related to that to say, are you aware that there's SIU that is, made proclamation to investigate legal practitioners, the doctors? Says, yes, I'm aware, and we're worried about that and we're concerned. Which one is the answer now? Because he just said he doesn't know. He was asked by the Premier, he said doesn't know. When put differently, same question, he now says he knows about such, they were all concerned about such conduct. Which one is the answer, CJ?
Do you have an answer, Advocate Msu?
Yes, Chief Justice.
Please go ahead and give us your answer.
Honorable Malema, when I say I know, it's out of reading on papers that there is concern about the shenanigans committed by practitioners. It's not that I have personal knowledge of who those people are or what is the magnitude of that. Thank you.
All right.
CJ, can I come back?
Yes.
Thank you very much.
Oh, sorry, Premier. Let me just find out from Commissioner Marumachaya if he wanted to ask a follow-up question.
No, I don't have any follow-up questions, CJ. Thank you.
All right. Carry on then, Premier.
Thank you
Oh,
very
and
much,
I should perhaps warn you that you don't have, you can't just ask a limitless number of questions. There are constraints.
Thank you. No. I just have two. I'm just
Okay.
concluding the first one.
All right.
On the same question that Honorable Malema was explaining further. So I just want to check from Advocate Msiwa, what court can do in ensuring that the money awarded, whatever process that has been followed, but that money ends up with the real people, mothers or the children themselves. What court's role around that other than just awarding that particular court judgment? Do you think the court can play a role around there in tightening up to ensure that there is no abuse there? Probably the money doesn't end up in the hands of those unscrupulous attorneys and all that.
Honorable Premier, what happens in court is this. A judge presiding grants an order in the presence of your legal team, the government employed advocate and state attorney, as well as the advocate who represents the plaintiff or the patient. Once an order is granted, it transits to the attorney's level. The advocates are no more there. And they mustn't be there insofar as how is the money distributed to the beneficiary. However, when I hear of this crisis, I take that, one, the court has no responsibility until your people, the organs of the state, investigate this. As you say, there's SIU. Investigate this And the investigation should be very simple here. The court order will have the parties, will have the order granted by the court. Your SIU should simply go to the families, that is the beneficiaries who were granted this money, to verify if the attorney in whose favor when acting for his or her client did in fact handed the money to its rightful destination, that is the beneficiary. Then the court, once advised that an attorney has misappropriated the money and the money was not received by the beneficiary, I take that the law will be taking its own course, because again now, that advocate or attorney who has robbed that innocent soul of her or his money must be taken to account, and the court must frown about that. That will be now getting to a criminal side, the criminal case of litigation, to the satisfaction of everybody of South Africa. That's how I believe court will get involved. You need to have a team that goes to each and every household whereby the mother or the father was granted or awarded a certain amount of money. Verify that easily with the court order and say, you got 16,000, how much has actually landed in the hands of the beneficiary? Out of that, the SIU may make life very easy. All the culprits will be caused to account. I thank you, Premier.
My last question now, CJ.
Okay.
It's unfortunate that we spent too much time on this one because it's a very, very serious issue out there. My last question would be a simple one to advocate. On average, you said you have done a lot of judgments when you were acting KZN and all that. So on average, what is the turnaround time in issuing judgments? Thank you.
The turnaround time, Honorable Premier, is 3 months, if I'm not mistaken. But I've set up a pace for me to be 2 months so that I achieve my ultimate intention, whereby I said I would prefer to see the Honorable Judge President of KZN employing 3 people to replace me.
Thank you, CJ.
Thank you, Premier. Commissioner Trollip?
Thank you, Chief Justice. Judge Msiwa, in the absence of evidence of reported cases, I wanted to ask you quite a pedantic question, but I think it's important because it speaks to attention to detail in writing. When you filled in or did you fill in your questionnaire yourself?
Yes.
In that regard, I noticed that there were some irregularities in the case between Tracor and the premiers and 8 others. There was reference to Olimoko when it's actually Ulimoko. And in the case between Makaula and Premier, there were gender inaccuracies. For example, you referred to a chieftainess as a chieftain, and then later you said she was denied the right to act on behalf of his son. Now, in writing, it's very important to get the record right. Am I right in saying that, especially as a judge?
Yes.
Okay, thank you very much for that. And my second question, Chief Justice, if I may, was in your answer in the questionnaire, you said you chaired an investigating commission dealing with mismanagement of funds and sex for jobs in Cocta in 2015. Were the people responsible for mismanagement of funds and sex for jobs held accountable? And what happened to them?
The terms of reference, Honorable Trollip, were altered once we commenced. We were confined with the investigation for the latter, that is sex for jobs. We made,
Sorry, could you speak in the mic?
thank you. The terms of reference were altered. Regarding the mismanagement of funds, we were told that no, this is not your scope, and we dealt with only the sex for jobs. We made recommendations and findings. Nothing happened.
Thank you, Chief Justice.
Commissioner Hassan?
Thank you very much, Chief Justice. This is perhaps unintentionally a follow-on on Commissioner Trollop's question. And it's really around, if you look at some of the matters you've been involved in, dealing with the rights of women, acting pro bono, also for other marginalized members of our community, we want to commend you on that. But the question is, and I'll ask it a little bit more broadly than Commissioner Trollop has, but given some of the challenges in the Eastern Cape, and I think we're all fully aware of what has been reported in the media and other ways, but how would you deal with sexual harassment more broadly in the court? And I'm aware that there's this policy and it hasn't yet been circulated, but I do think it's important, commissioners, for us to understand that, especially given the challenges in this particular division. And then I'm also interested, let me ask that and then I'll ask my second question after. Thank you.
Do I understand the commissioner to say, how would I deal with the sexual harassment?
Let me assist you. How would you deal with a potential culture where sexual harassment may or may not be normalized, but what would you do to combat it within the court? And I mean this, of course, in terms of matters you will preside over, but I mean this also internally in terms of how things have been working. And I'm just asking because it is an issue that has come up in the public domain. Thank you.
Sexual harassment is an atrocious and unbearable offense. I think that there are statutory prescripts of how to deal with anything that has got to do with sexual offenses. I will abide by that and enforce them. Those laws and prescripts. At the same time, amongst the members or amongst the staff people, it's something that needs to be taught, that needs to be spoken about in a manner that is discouraged. I thank you.
Okay, I don't know if I'm entirely satisfied with that, but I do recognize that I asked a more broad, generalized question. I'm also interested in, and we've seen it a little bit in terms of your legal jurisprudence to some extent, about how you'd infuse activism and human rights in your cases. But I'm interested about how, going forward, and I'm trying to phrase it correctly because I might use the wrong legal jargon, so I'm going to speak as a layperson, but how you would be able to, let's say, enhance the element of human rights, because we do see it as a thread throughout the legal jurisprudence, but I would be interested to know what will be done to elevate it. And I'll leave it at that, CJ. Thank you.
The Constitution of the Republic of South Africa is founded on the values of humanity and dignity and freedoms. And further, the Constitution enjoys a judge or a court to, in the exercise of its own inherent authority, to ensure that the Constitution is adhered to, even in the exercise of a common law, in the exercise of a discretion in terms of common law. That common law or customary law, that common law must be subservient to the Constitution. So for a judge, if one is presiding, is enjoined by that provision of the Constitution, I will not be different. Mine will be to express that compliance with the Constitution, and when necessary, I will always discourage anything to do with sexual harassment in the establishment. I thank you.
Deputy President Zondi.
Thank you very much, Chief Justice. Good afternoon, Advocate Msiwa.
Good afternoon.
I was listening to the debate between you and the acting Judge President of the Eastern Cape. And it will seem to me that the debate was about your ability, was about the number of judgments that you have written and the number of judgments which have been reported. So would you assist us in terms of the judge? Because it will seem to me, judging from the line of his engagement with you, that he was not satisfied with the number of judgments that you have written. And based on the number of judgments that you have written, it will be difficult for us to assess your suitability as a judge. So I want you to assist us. Do you have judgments that have been reported? And if not, why did you not mark them reportable and see what happens? Thank you.
In the Eastern Cape, when I started acting, I did not even know who is responsible for reporting judgments. I had written judgments at the time of Judge President Sangoni's tenure. I have also written judgments subsequent to that, and even in 2024, when I was in Grahamstown, I've written judgments, but I didn't write reportable. I do not have an idea about the reporting of judgments, how it is done. I repeat myself. I never even inquired or investigated how judgments are to be reported. I thank you, Judge President.
I make a follow-up, Chief Justice, on this. I was checking the judgments, that is the TRACO, Military Council, all these judgments that we're quoting. These are judgments relate when you are the council and you were led, you were not the lead council. That is, in all of those that we have mentioned thus far, there was a lead council. It was not. There was a lead council. For instance, in Traco, you were led, and then in this military council, you were led. Do you have a judgment where yourself now, you was the lead council, either where you were lead council, either in the Eastern Cape or in the SCA or some other division? Just to make up, because all this that we have relied on somebody else. That's where my difficulty is. I'm adding to that question.
I remember recently a judgment where I was alone representing the Premier and the President of the Republic, which has been written by Judge Mtombo or Nomnembo. I'm not sure how far has it gone, but I know I read it. It is written reportable.
No, but that one is subject to leave to appeal. You and me were involved on that one. Can we put aside? There's an appeal, there's a leave to appeal which is yet to be had. Do you have any case in which you have been by yourself? You were the counsel who appeared? Because all the judgment you cited, you were led by some other. I'm trying to make up to what the deputy president is saying and what the JP, so that because you rely on this judgment for reported judgment.
I can't
I'm
remember.
trying to give you a space so that you say, no, this is the case where, for instance, as a counsel, I've appeared.
I do not remember one, Honorable.
Follow up? Okay. Commissioner Pillay?
Thank you, Chief Justice. Good afternoon. I do want to put a general proposition to you first, Counsel, and I do so because I don't want to be unfair to you much later. I went quite carefully through each of your judgments, and it took me a long time. And that's really the gravamen of my complaint, which I want to put to you. I find your judgments very difficult to follow. They're unstructured. It's almost impossible when you're reading your judgments, particularly at the beginning of the judgment, to understand exactly what the issues in dispute are and what it is that you are focusing your judgment on. And unfortunately, this is the thread that I find in all of your judgments that you've placed before us. Not to mention the fact that an issue that Commissioner Trollope has raised, that your judgments are riddled with errors, typographical errors. I just want you to comment on that overarching submission first, and then I'll deal in more detail with what I'm putting to you.
Commissioner, I haven't understood Commissioner Trollope to say my judgments are riddled with typographic errors. Nonetheless, I won't dispute that, but I don't remember so. The point is, when I was trained to write a judgment by a senior counsel whom I relied on, a certain pattern was put to me as you start by introduction, and then you come to the facts, and then you come to issues, and then you come to law applicable principles, and then you come to assessment of the evidence, and then you come to the order that you make. So that is the formula I have acquired in KZN. Respectfully appreciated that. Before that, I've never been taught how to write judgment. So this is why I was excited and very grateful about the opportunity of KZN.
Mr. Msiwa, let's test that in relation to at least one of your judgments. I don't have time to take you through all of the judgments. Let's look at your Newlands judgment.
Yes.
The Newlands Sporting judgment, you'll find that at page 56 of your bundle.
Page?
56 of your bundle. Are you there, Mr. Msiwa?
No, the top page will be 4 of page 56 here seems.
I'm looking at paginated page 56.
Oh, my 56 deals with something else, not the one about the new lands. But I know the Newlands case because it dealt with football clubs in
Yes.
Durban that were denied the right to participate in an elective conference.
Yes, it dealt with challenges to decisions taken by SAFA at the elective conference.
This is 56. Okay, thank you. Thank you. I've been assisted, Commissioner.
Thank you. So you're looking at paragraph at page 56, that's where your judgment begins. And you take some time to tell us what the issue is in the judgment. But if you look at paragraph 7 of your judgment, you say that in salient form, it demonstrates the shortcomings of the elective conference and submits that on both procedural and substantive grounds, the decisions taken in the conference fall to be set aside. So this is a challenge to decisions taken at the elective conference. And ultimately, you tell us that the gravamen of the complaint is that clubs were prevented from participating because they were not in good standing. And that's really the central issue in the judgment. You recall that?
I do.
Right. Now, if you go down to paragraph 26 of your judgment, you say there that it's unchallenged and not disputed.
Paragraph?
26, paragraph 26 of your judgment.
Yes.
You say there that it's unchallenged and not disputed that the clubs lack good standing. And that's really the central point of the entire case.
To me, it was not the only one.
Not the only one, but the central point. You say that elsewhere in your judgment.
Let's read the preceding sentence, Honorable Commissioner. This version about lack of good standing of applicant clubs has not been refuted by the applicant's counsel. Then I say it remains unchallenged and not disputed.
And then you make a finding.
Yes.
Now, you do it again at paragraph 32. You say something else. You say that it's common cause that the applicants did not have good standing at the electoral conference.
Yes.
So you see the difference in the two findings already. On the one hand, you say that it's undisputed, but you make a finding that they lacked at the elective conference. And on the second the second instance, you say that the applicants did not have, it was common cause that the applicants did not have good standing. Do you see that?
Yes.
Now, what you do for the remainder of the judgment is where I have a difficulty, Mr. Msiwa, and you'll see that from paragraph 33 onwards. You talk again about the fact that the applicants were not in good standing and the amount of paper it took just to establish that point, which according to your judgment is the central point. And then you say, you say in paragraph 34, it was legally apt for the respondents to deny the applicants' participation in elective conference. It is to date incumbent on the applicant to purge their non-payment of either affiliation or subscription before they are terminated as members. Now, that issue didn't serve before you.
That they had not paid.
No, what the implication of non-payment is for continued membership. That was not before you. What was before you was a challenge to decisions taken at the conference.
The matter was presented before me and I listened attentively. am not able to venture beyond what I've written here, because my understanding was that it was common cause that these clubs had not paid. And in fact, as a result of that, they were frustrated, in fact, for not to even pay. They were frustrated by the unattended approach adopted by the NSL. So in frustration, they didn't pay.
Mr. Msiwa, what you're dealing with in this paragraph is the implications of non-payment on their future membership of SAFA. And you're expressing yourself here on the fact that SAFA should terminate their membership. And you say further, if you look there, you say that in paragraph 36, sorry, in paragraph 34 is where I had you earlier. You say, I state so on assumption that SAFA will abide by the rules of natural justice in terminating the applicant's membership. So you're expressing yourself on matters which were not before you. According to your own judgment, you had identified that the issue was the elective conference and whether or not the decisions at the elective conference were lawfully taken. And now you're delving into the impact of non-payment on their future membership with SAFA. And it gets worse. If you look further down what you say there, you say the applicants have no confidence in internal SAFA mechanisms, hence they are averse to mediation and arbitration. It is so because SAFA structures fail to attend to the club's grievances. Instead, SAFA adopted a radical, unfounded stance that the clubs are not their members. Acting prudent, SAFA is obliged to inquire why so many clubs did not participate in voting of the executive. You carry on, since the return of South Africa into international participation, South African soccer and some sporting codes are lagging far behind in sport administration compared to their counterparts at a global level. It is time for all these sporting codes to improve their acumen to bridge the gap between South Africa and other international sporting codes. It goes on and on and on. You're traversing material which is not at all relevant to what you yourself identified as the dispute before you, which is the legality of the decisions taken at the elective conference. Now, you'll recall, Mrs. Msiwa, where I started with my questions, and that was my difficulty, and I spent a lot of time going through all of your judgments. My difficulty is that they all demonstrate a lack of clarity and cohesion in terms of how the reasoning is set out.
Commissioner, I honestly dedicated myself in this matter, and I applied my mind on the facts that were presented before me. Logic might have escaped me somewhere along the line, if at all, but the parties did not even appeal on this matter, and the matter was resolved and was finalized. I am not omniscient. There can be mistakes spotted by another person in my writing of judgment, but as far as I'm concerned, I did the best that I could.
You do accept the flaws that have been pointed out by Commissioner Pillay?
In doubt, Chief Justice, I do not recall even the arguments. Let's remember this matter was argued full-blown, and perhaps out of my picking, there might have been disjointment, and of course, I may have committed some shortfalls.
Could I just have a short follow-up on one aspect? Advocate Msiwa, you're saying that no one has ever taught you how to write a judgment, and you sort of had to figure it out, I suppose.
I beg yours, Commissioner.
You're saying that no one ever taught you how to write a judgment. You sort of had to make it as you go along.
Yes, Commissioner.
I mean, the only thing I'm concerned about that is that Okay, maybe in 1995 that would have been legitimate. But now there are so many programs training people how to write judgments, specifically people that are interested in joining the judiciary. There is a judicial institute. So the access to training on judgment writing is so available. So I'm not sure whether to accept your defense on that issue.
Honorable Commissioner, you may not accept my defense because I never attended any of those. I have been looking for an opportunity to attend to that, but the last one where I was gonna to benefit could have been the very, very last. I can't remember, but long after this judgment had been written, I'm still eager to go and learn.
Commissioner Malema, your hand was up at some stage, and all the questions you put to the candidates were follow-up questions. Do you still want to?
I've got my questions.
Okay, go ahead.
Thank you, CJ, and thank you for adjusting the aircon because it was horrible the whole day. And it was like the power relations are not properly balanced because the aircon can communicate something else as to who is in charge. I just want to ask, so I can make a quick follow-up on the same. You said you don't remember, no, let me ask it differently. How many judgments did you write since acting in KZN and Eastern Cape? And the CJ said, not exact number, just an estimate, a rough estimate.
A rough estimate could be 15 somewhere.
15.
Yes, 15.
So when the CJ asked you, you said you don't, you've written so many, then there, you don't remember how many judgments you have written. You don't remember where you were a leading counsel. You don't remember that.
I do.
Where a judgment was made, not the appeal. The case is settled, is done. You were a leading counsel. You said to Commissioner Nonches that you don't remember which one.
If Commissioner Malema would talk about the reported ones, I do not.
No, not reported.
Oh.
Where you were a lead counsel. That's what he said. He kept on saying that. Where you are a lead counsel, where a judgment has been passed, whether reportable or not.
Okay.
You said you don't remember that.
I may remember. I may remember, Honorable Malema, some cases where I lead and judgments were delivered.
You remember? No?
Yes, I may remember.
Where you were a senior counsel.
Yes.
There was no lead counsel.
No.
Please take us through maybe one or two. Because you said you remember now. Earlier on you said you don't remember.
No, I was thinking about the reported ones. So I'm talking about now the unreported ones where I lead.
Any judgment where you are a lead counsel.
I have led in matter of land affairs where there's invasion next to Umtata at Mandela Park about land invasions. I led the late Nancy in those matters, a series of them. I also led Matodi Advocate Matodi in a matter of municipality. That judgment, we were dismissed. We were for the plaintiff. We were for the applicant. I beg your pardon, my lord. I remember leading Mr. Khili in a matter for health. I remember leading Lady Advocate Ngalo in a matter. Can't remember whether transport or education.
That's fine. That's fine. SC. I've got a limited time. Now, equally, you don't remember how judgments get reported. I'm going to a different point. That's what you said earlier on. You said, I don't know how judgments get reported. I just see them, some written, reportable. You don't know how a judgment gets reported for it to become a reported judgment. You don't know that.
I don't know that.
You don't know that, SC.
I say, I confirm.
You said to Chief Justice, you said you are a member of the ANC and you don't know anything against that. And if that, there is anything of that sort, that will be against your philosophy as a judge. You remember that?
I don't get your question clearly, Honorable.
You remember you said, if you are a member of the ANC and you don't know of any rule that makes you not to be a member of the ANC, and if there is such, it will be against, I'm not quoting you straight, but it will be against your principle or philosophy because that's who you are, a member of the ANC. And you can't wake up one day, you are told you are not a member of that organization. That's what I understood you to be saying to Chief Justice earlier on. I can't remember what she said at the end, but your answer was that you are a member of the ANC and that's who you are.
Honorable Malema, you must have not understood me. I said I don't know of any rule that says that prohibits me from being a member of any political organization for that matter. But now I am told, straight away I will relinquish that.
You were told by who?
The judge, the Chief Justice said a judge cannot be a member of a political
Thank you.
party. Yes.
That's where I want the judge, an aspirant judge. Then the aspirant judge also never took any opportunity that presented itself after 1995 to undergo judgment writing and come here, present himself as an aspirant judge and says, well, the last one which I could attend, I missed it and therefore I never took any training, even when there are so many opportunities that came about our democracy where even the young ones are now learning how to write judgment. So all I'm saying, and that's the point I'm going to make when we go into deliberations, and I don't want to be unfair to you. You come across as being complacent. Maybe because of your high decorations or whatever the reason might be, that you did not try anything in preparation of this. To a point, you don't remember your judgments, you don't know how judgments get reported, you don't remember, even when given opportunity now, you still struggle to tell us which judgments were you leading, and then you say you don't see anything wrong. Now the Chief Justice tells me, an aspirant judge who prepares for this hearing, where such matters have been canvassed, including on political party affiliation. You say, well, I don't know anything of that sort. And you are not just an ordinary person. Senior counsel, who's an acting judge, says, well, I didn't know, but now I know the CJ told me. I'm going to argue that you are not suitable to be a judge. And worse, with that comments which were made on your judgment writing, will I be fair that I must live here with my rightful conscience that we have appointed a person who said, I don't know that there is anything wrong with being a member of the ANC, even when you are a judge. But since the Chief Justice said so, I'll relinquish it with immediate effect. It is not in your consciousness. It is not in your conscience that a judge cannot belong to a political party. If we did not have a Chief Justice with a wisdom, judicial wisdom, and just leaves you like that, you are going to continue to be a member of a political party because your conscience doesn't tell you that there is anything wrong with it. Only the Chief Justice told you that.
Just Honorable Malema, you will be unfair to live with that impression. I'm not complacent. I come here to apply for consideration, but everyone is entitled to make his observation about me. Being a senior counsel, I suppose, does not necessarily mean I should know all. This is my first encounter to come in this in any interview in any interview in my life. So my missteps or shortcomings I should be penalized for them, but one should also take cognizance of the fact that this is my first encounter in life that I come into the interview. Insofar as question of being a member of a political party, conscience tells me when somebody says, this is not right at this stage. Surely, consciously I say, I am out of it. For instance, for me to dispense justice, I know I don't have to have any affiliations. This is why I have been chasing and litigating for destitute women and school learners against the government in the Eastern Cape. I have not for once been in a position to say I'm to be biased in favor of the ANC government. I have enforced people's rights against an ANC-led government of the Eastern Cape. This is what I do with pride for the people of South Africa.
Chief Justice, all I'm saying, I'm not saying you must know everything. I'm saying you don't remember where you were a lead counsel. You don't have, that is not supposed to be in law books or in anywhere. It's you, because you pride yourself as lawyers and judges with your judgments and cases that you lead and win or lose. You know, this is my case. You don't know how a judgments get reported. You don't have anything to show that you attended any course on judgment writing. And that's what's going to be 80% of your work. You have to write judgments. You don't know that. You don't know that you don't have to belong to a political party, which means I must live here. Having recommended the appointment of a member of a political, I'm not saying whether you ruled against ANC or not. I'm talking about the membership. That if we live here today we've appointed an ANC member to become a judge, and where judiciary is accused of being captured. Aspirant judges who come here, they will tell you, I've been a member of the ANC and I resigned since a year ago or 2 years because they knew now I must start cleansing myself of these things. And that's being aspirant. So being aspirant judge means you'll also research what are the common questions there and all of that. All of that, you did not take an effort. You don't know how many judgments you have written. And when I ask you, say, I won't know everything. I'm not asking everything. I'm asking about a rough estimate. Not even me, the Chief Justice does that. That answer doesn't come out convincingly. I'm saying, and this is what I'm going to say, even with your response, I'm not convinced. And I take it, what you are saying is your first experience, first time, and all of that. I'm not convinced you are ready to take the bench. I think, in all fairness, it will be even fair to yourself to give yourself sufficient time. They can give you acting stint, and then you give yourself time to also attend aspirant judges courses to improve on this knowledge and to prepare even much better in the next meeting. Because, I mean, for the next interview or whatever happens in the future, a person who's known by CJ, they've gone to school together, the CJ makes such a disclosure before us. And then in the response, we hear such a complacent person. Even when the CJ said, no, well, I'm going to act fairly, I don't have a problem, but we know each other. Perhaps that might have been something that misled you, that you know her and therefore things are going to happen. They are not going to happen here. Here you come prepared. Thank you very much.
Commissioner Pillay, did you want to respond to Commissioner Malema's comments, Advocate Msiwa?
I have.
Well, I thought you did. You already did.
I
Yeah.
did, sorry.
Sorry. Commissioner Pillay, I'm sorry
Just-
I cut you short. You still have
Sorry, Chief
issues of
Justice, just the
deputation.
adverse issues to raise. Mr. Msiao, I just want to raise with you some of the adverse comments. You were given notice of these adverse comments, and unfortunately, your response didn't address all of the adverse comments. The first one is the adverse comment from the GCB, and it relates to your age. They raised the fact that you are 65 years and 7 months, and that may work against you. So if I could ask you to address that. And the
Yes.
second adverse comment by the GCB is that you claim to represent indigent people, but they are unable to locate judgments which record that you do represent indigent people.
Can I start with age, madam?
Sure.
There is a say that the more one grows old, there's a need to reciprocate such with humility. Humility goes with maturity, age goes with maturity. I so submit that when one is a judge, there is an obligation of being very humble, treating the practitioners, even the worst newly admitted one, with respect and aplomb. And also keep the temperament. No, it must not be, you mustn't have a high temperament. Therefore, this calls for the reactions and responses. Say you meet up a newly admitted practitioner who hits hard at judicial officers. There are some who do so. The manner of dealing with that is contained through maturity, because you don't have to react and respond harshly. You have to try to show him better how to think and how to present his case. Yes, you do so while taking cognizance of the fact that behind this person, there is a small person there who is the litigant, who is not aware of the techniques that are required in court. So I am that type of, I subscribe to that principle. So I submit that age is a benefit, because the manner of handling issues differs much when you are young. You handle matters in a very mature way when you are old than when I was young. So this is my submission. Age shouldn't be, as far as I'm concerned, shouldn't be a bar for consideration of a judicial appointment. I have illustrated that in court you meet up various type of characters. Some of them are very robust against judicial officers. Some of them are very humble. But the duty the judge has is to treat all of them with respect, but show them in a very educative form, so that even the worst young practitioner dares to come to your court and say, I will learn in that court.
Just in relation to that point, Mr. Msiba, I just want to put to you what AFT KZN submitted to the commission. They said that those who appear before you said you do not have a good handle on a busy motion court role. They said that you argued unduly with counsel during your acting stints. And they said that you did not have a courteous approach, particularly with juniors who appeared before you.
Let me deal with the IFT Devon. I've seen that. I lack particularity. I couldn't respond to that because I do not know of any case of this nature. And whereby in Devon is very good, very good. The colleague judges, they would advise you of anything that is unbecoming you commit in court because there's a live communication between the judiciary and the practitioners. So this takes me by surprise because I know in Devon, KZN, I could have been asked about this. I lack particularity. However, having said so, I do not know if the very IFT people do know me. I believe they do not know me. Whoever has penned this negative and adverse report in this way, because I was in Durban and I do not recall arguing with anybody so adversely that there's this report. Courtesy of approach, I do not know where that comes from, how did I do it, on whom did I do it. Dealing with the issue of, I want to think the other one, the respect. I've read that there's a complaint that I respected seniors. This is blown out of proportion because in court I treat everybody on equal footing as practitioners and court officials who are there to work with me to arrive at a fair and a just decision. Now, in that process, of course, there's ethical obligation, which is known as a practice. Senior counsels are afforded priority in court. You do not let, as a presiding judge, senior counsels to stay in court without any reason. They are given preference by virtue of their patents. It leaves me with impression that when I'm accused of having been biased in favor of senior counsel, the author who penned that adverse report is the person who might have been newly admitted, who did not realize what it means, how to treat practitioners as they are in court. So I beg to disagree with this. However, I can also go on further and say, yes, there were 2 or 3 days in court when I was running a motion court in Durban where things didn't go right. Firstly, because firstly, I had an intern, a young brother, a young boy, a young man, who was my registrar with no experience whatsoever of being a secretary's judge. Remember, that is a very important supporting element for you as an acting judge. I had thought that when he came late sometimes, and when he didn't pitch up early to collect me on the corridors, I had thought that he was mischievous looking at his age. And one day I caught him in the morning with his head banging down on the table. I again thought he was drunk. To my surprise, I called him because I was keeping on Raymond, advising him to improve. He had lost his brother. First he had lost his mother. He had lost his brother almost in the same month. And on this day, when I took him to my office with his eyes red, he divulged that even his contract was not renewed. He cried, he wept. I empathically also joined him in crying. I couldn't avoid it. So at that time, the court was awaiting for us, but we were both, to me, out of Ubuntu, I saw myself crying. I had all the empathy for him, all the empathy, because this gentleman was in despair of life. I am not a person who can be happy and have happy nights when seeing any child or a brother with a potential, or not even a potential for that matter, committing suicide or in a manner in which that fellow was. So I went to court and apologized to the practitioners in court openly and asked them to give me time to deal up with a glitch that humanly had affected me. I did that twice in Durban. So I will agree that the author here is trying to smack me with adverse allegations that I am not competent to run motion court, but this is not borne out by my whole term being in Durban. I say I will take responsibility of these 2 days because this fellow was completely destroyed. I had a senior judge and also the JPs who are so motherly and maternalistic, who are actuated with Ubuntu. But I could see that when this man cried the way he cried, I knew that I won't go to them, not because I despise them, but because they are so caring mothers. There could have been worse problem for that court. I thought I managed it for those 2 or 3 days. I thank you. I
Mr.
cried
Msiba, if I
out
understand
of
your answer, you're saying that at least on 3 occasions you accept that you had difficulty managing the busy opposed motion role, but you attribute it to the circumstances of your registrar.
I have never had the hardship in running the court in KZN. Never. But I say there's this intervening problem that humanly affected me on those days. I say 2 or 3, I can't remember. But I went to court and apologized to the practitioners and asked for them to excuse me because I was attending to this man's human problem, which had affected me too. I cried myself. It pained me to see this boy crying.
Just lastly, Mr. Msiba, I just want to clarify something. You mentioned that you were caught by surprise. I just want you to confirm that the JSC does have a very high-functioning objections committee, and that you were given a copy of the AFT and GCB objections, and you chose not to respond to the elements of the objections which I've put to you today.
I hear you talking about GCB as well. The GCB deal with it. The GCB has denied, or I read it to say I was never a head of the LLP subcommittee. That is borne by evidence that that is incorrect. Maybe the memory or the records of the GCB, institutional memory, let me say so. Maybe the institutional memory of the GCB is depleted somewhere. In 2013, I was the chairman of the LLP committee. So it surprised me that the GCB had written that way. In response to that, I had attached to the response the report I made to AFT, to which I was a member, in 2013, reporting our meeting with the Department of Higher Education as well as the LSSA. I reported in that official capacity as the chairman of the LLP subcommittee of the GCB. I had also reported to the GCB the same. I was tasked to carry out certain investigations, which I did. Therefore, the adverse report made in that regard by GCB is not accurate.
Sorry, Chief Justice, we just need to clarify this. There were two adverse comments by the GCB. There is one that you have addressed. We rejected that because you provided a 2013 document showing that you were in fact part of the GCB LLB committee. So we rejected the comment by the GCB. There was a second comment which you didn't respond to, at least not satisfactorily, which is that in the case of S versus Vilagaz, you had not delivered the judgment within the 6-month period at the time you applied. And then in your response, you say, well, you gave the judgment in February 2024 and you thought it had been delivered. I thought that, certainly we all thought that that response was not satisfactory, because if you sent a judgment in February 2024 and you applied in June 2024, surely you would know if that judgment was handed down or not, particularly because there were two of you. It was a court of two. And so we couldn't understand what exactly you were saying there. So that's the issue on the GCB that you must address yourself on, not the first issue, because we agree with you on the first issue. We thought your response was satisfactory. It's really the thing about whether your response about that judgment is an acceptable response or not.
This judgment is the most grievous mishap has ever happened in my hands. If Honorable Ngoketobi look at my judgments in Durban, this is an exception. Everything got lost. It's a matter that has got to do with a lady by Bodlani. And it's the only judgment that my secretary ever tried to type. He took so long to type it. After I had taken it to my senior, there was a to and fro of it after reconstruction. It took a long time. Indeed, when I applied in May or June this 2024, because I had spoken previously with my lead judge, as far back, there were to and fro. I would even go to Durban specifically to search for this judgment. I would even go to Maritzburg to discuss with her this judgment issue. We had to reconstruct this because everything got lost on my table. Everything. And my notes were very scanty because I requested to write this judgment during the proceedings after there has been debate, there's been argument submitted. I, out of zeal, asked her to grant me permission to write this judgment. Least did I know that it will be having these problems. Now, by January, I spoke to her and we agreed that the judgment was final. I left it there and we agreed that he would sign it and deliver it. That was in January. Then in June, when I applied for this interview, I had honestly believed that the judgment had been delivered. It shocked me when it came as an issue. What did I do thereafter? I phoned Mrs. Govender, who confirmed that the judgment had been delivered in February. So this is the explanation I have about the judgment. This is the only judgment out of my judgments that has exceeded the period of 3 months. The only one out of several. I thank you.
Could I just get some clarity? I mean, in the answer you've given, I'm getting more confused because you say you lost the record, and then how was the judgment written if the record was lost?
The judgment was an appeal. It was an appeal judgment, simple on a question of whether there were compelling circumstances for the presiding magistrate to deviate from invoking the Minimum Sentence Act. It was a rape by a biological father of her child of 9 years. The previous magistrate had found that had sentenced him to a suspended sentence, I think 5 years, suspended for 3 years. Then the other magistrate confirmed that there were no compelling circumstances to deviate from the Minimum Sentence Act. So a life sentence or a grave sentence was imposed. I wrote to confirm the second magistrate's issue because the state, the appellant had appealed, Vilakaus had appealed. So I thought it's a criminal matter, let me do it. I was interested to write it.
No, I'm
So
not asking you
my-
that. I'm asking how you wrote a judgment when the record was lost.
I asked from my senior judge his records because I had none. He had the heads of argument. He had the record notes that he scribbled. I also scribbled mine. I constructed the judgment out of that material.
No, I mean, I really don't understand. Anyway, sorry, Chief Justice.
Neither do I, but is there any point in pushing it further?
No, there isn't. I apologize.
Yeah. Commissioner or JP Mlambo?
CJ, I have been covered. Thank you.
Thank you. Commissioner Moimang, do you still want to question the candidate? Is that him? You had raised your hand. You still want to question the candidate?
No, CJ, I'm fine now.
You covered? Okay, thank you. Advocate Msiwa?
I had my hand up, but I can let it go. I can let it go, CJ.
Thank you. Thank you for making yourself available for this vacancy, Advocate Msiwa. You're excused.
Thank you. Thank you, CJ. Thank you.
May I ask non-JSC members to clear the room, please, so that you can deliberate?